Walshe expected to be sentenced to life in prison without the possibility of parole. Criminal defense attorney Joseph Tully joining us now to break down more. Interesting, we had talked about this, Joseph, before the jury got the case, and it was that Brian Walshe had already admitted and pled guilty to disposing of the body, but it was now leaving up in question if he had in fact killed his wife. The jury seeming to believe that beyond a reasonable doubt he so in fact did and premeditated it.
Correct, yes. And for this jury to have reached this conclusion, it had to be the only reasonable explanation for what happened. So that's really what reasonable doubt means, even though there was no body. His lies to police, I think, were very damning, talking about that she had left on a emergency work trip. There was a guest who told police, look, there was no emergency. There was no flight that day. The phone evidence was inconsistent. I mean, he just had a lot of lies. His Google searches were completely damning. And the jury, I think, did the right thing here. And the evidence proved it beyond a reasonable doubt, as you said.
I think at times people may think, well, if this is a murder case, especially a premeditated murder case, and then you don't have the body here of the victim, there's the thought that you can't convict beyond a reasonable doubt because, well, there's no body. Did they in fact die? Were they murdered? But yet here we see, case in point, that it happens.
Correct. Yeah. So basically, it's the Gone Girl defense that I've seen in the national media on main big cases following that movie that came out of that same name in the book of that same name. However, here, you know, the Google searches, I think, just left no doubt in the mind of the jury. You know, how long before a body starts to smell, how to stop a body from decomposing. These are January 1st, the last date that his wife was seen alive. You know, best ways to dispose of a body. And then there's no body. So I'm sure the prosecution was able to argue to take a fact that's usually negative, that there is no body, and turn it into a positive. Look, ladies and gentlemen, he was researching how to get rid of a body, and that means he did it. So I think the jury did the right thing here, and I think the evidence proved it beyond a reasonable doubt. There was no other reasonable explanation for everything that happened.
How much did him pleading guilty to disposing of the body work in, I guess, against him, right, in the end? Because it seemed like a calculated risk by the defense to have him plead guilty to that charge first. So you're probably right. So in my legal mind, I'm thinking, look, he took the things that he was for sure guilty of off the table, and then that at least gave him a chance to argue something at jury trial. But I think, you know, in the minds of the jury, they could very well have just thought, well, he's already pled guilty to this, you know, to dismembering a body and to lying to police about it. So, and use that against him. The law instructs you otherwise. But in the mind of the jury, they might have just used common sense. Were they privy to that charge and to that pleading?
Normally speaking, they can be privy to that, but it is very, very limited unless the defense opens the door. Here, I didn't see that big of a deal being made about that issue. There was some talk. The defense was saying that he would testify, and he ended up not testifying. So I don't think that the prosecution was able to use as much of it as they could have had he testified.
Because there was overwhelming evidence, at least to that charge, where there's surveillance video of him at the Home Depot, at these building supply stores, buying the cleaning, you know, the instruments, if you will, to get rid of the body. And there's receipts and all that. So was that not used in the murder trial?
Yeah, so that was used in the murder trial. It goes to the conduct of cleanup after killing. So that would have been used. So really the only strategic advantage that him pleading guilty would have given to the defense is that if he were to take the stand, he would be able to look at the jury and say, listen, I pled guilty to what I was guilty of, but I'm telling you right now, I am not guilty of this murder. And that didn't happen. So really,
it took a few issues off the table in terms of it not being relevant, but it would still be able to be used against him in the jury trial.
What's the calculus by the defense here, the defense team, to put your client on the stand? Because he did not take the stand, but that's always something that seems to be saved to the very end once you see all the evidence and what the government has put on.
Yes. So I like to put my client on first. I think in the movies they put the client on last because it's more dramatic. I think it sets a better tone. Really, legally speaking, it's always your client's choice. Your client can decide to take the stand or not take the stand. You can want your client to take the stand and they can refuse, and it's their choice, and vice versa. Here, I don't know what the practical strategy was. Maybe there's a lot of lies here, a lot of inconsistency, a lot of things that he said that were provably wrong. So they could have said, look, he's not going to have good credibility on the stand, or he's not likable, he's not a good liar. I don't want you to take the stand. And maybe he listened, or maybe it was his choice. We'll never know on that.
It's got to be tough to hear there from your own attorneys and be like, you're not likable, and you're sitting here looking for murder of your wife and the mother of your children. We'll see what happens next here, as he's now again going to serve likely life in prison, what that looks like, and if the appeal process, what happens next. But always, Joseph, good to have you break that down with us for the latest there out of Massachusetts. Thank you.
Yeah, thank you.
Back here at home, Prince George's County Executive Aisha Brafeboy and the police chief, George Nader,